All right, it's beyond 9:30, so I'm going to call the House Judiciary Committee to order. And first, I would recognize Representative Tripp to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. All right. So first, I'm going to open the hearing on Constitutional Amendment Concurrent Resolution Number 7 relating to the presumption of innocence. And I recognize the prime sponsor. Representative Potenza.
Thank you, Mr. Chair, and thank you for the committee. For the record, my name is Representative Kelly Potenza, Stratford District 19, Rochester Wards 1, 2, 3, 4, and 6. I'm just going to go into my testimony just because it's a little lengthy. And so giving people the option to vote on amending the New Hampshire Constitution to explicitly state that in all cases and suits of the state against one of the people, the defendant shall be innocent until proven guilty is important for several reasons. It strengthens due process. While the presumption of innocence is already a fundamental principle in American law, explicitly adding it to the state constitution reinforces the commitment to protect individuals from wrongful convictions and unjust government actions, preventing government overreach. By enshrining this principle, the amendment ensures that the state always carries the burden of proof, preventing potential abuses where individuals might be presumed guilty without sufficient evidence. Clarifying legal standards. Some legal proceedings, such as civil asset forfeiture or certain regulatory violations, may not afford defendants the same presumption of innocence as criminal cases. This amendment could help ensure broader application of this principle. Empowering voters. Giving people the opportunity to vote on this issue promotes the democratic process and participation and allows citizens to directly influence how justice is administered in their state. 5, setting a precedent for other states. If passed, this amendment could encourage other states to take similar steps, reinforcing constitutional protections nationwide. The principle of innocent until proven guilty, unless proven guilty, is already a cornerstone of the U.S. legal system, primarily recognized in criminal law. However, adding this explicitly to the New Hampshire Constitution would strengthen its application in a few ways. Current U.S. and New Hampshire legal standards. The 5th and 14th Amendments of the U.S. Constitution provide due process rights, ensuring that no person is deprived of life, liberty, or property without legal procedures. The presumption of innocence is a principle recognized in U.S. courts, primarily based on precedent rather than an explicit constitutional provision. The New Hampshire Constitution Part 1 Bill of Rights already includes protections related to due process and legal fairness, but this amendment would make the presumption of innocence explicitly clear in all state actions against individuals. Why this amendment matters. It closes legal gaps. While criminal cases follow the presumption of innocence, some administrative and civil actions by the state may place the burden on individuals to prove their innocence. This amendment could reinforce fairness in such cases. As I already talked about in limiting potential government overreach, without this explicit language, further legislation or judicial rulings might shift the burden unfairly in certain situations, such as regulatory violations or forfeiture cases. And it prevents legal erosion. Codifying the presumption of innocence in the state constitution ensures that it remains a fundamental right, regardless of political or legal shifts at the federal level. So in comparison with other states and some historical examples, while the presumption of innocence is a well-established principle in U.S. criminal law, it's not explicitly stated in the U.S. Constitution. Instead, it comes from case law, particularly in 1895, a Supreme Court decision, Coffin versus United States, which affirmed that defendants must be presumed innocent until proven guilty beyond a reasonable doubt. Some states have taken steps to reinforce or expand this principle through constitutional amendments or legal reforms. Louisiana in 2018, they voted to overturn a law that allowed unanimous jury verdicts in felony trials, reinforcing the idea that defendants should have full protections under the law. Texas and Michigan, they have constitutional language that protects due process, but doesn't explicitly state a universal presumption of innocence. Historical cases where this principle was challenged, civil assets forfeiture nationwide. In many cases, law enforcement can seize property suspected of being connected to a crime without requiring a criminal conviction. Critics argue that this flips the burden onto individuals to prove their innocence. A constitutional amendment in New Hampshire could make such practices more difficult. Internment of the Japanese Americans in World War II, that's Korematsu versus the U.S. The U.S. government detained thousands of Japanese Americans without individual trials, violating due process. If stronger constitutional protections had been in place, such actions could have been legally challenged more effectively. Post 9/11 detentions, case of indefinite detention, such as those under the U.S. Patriot Act, raised concerns about presumption of innocence being bypassed in national security cases. So, how could we set a precedent? If passed, this amendment would make New Hampshire one of the first states to explicitly enshrine this protection in our Constitution. Other states may follow, leading to national conversation about reinforcing legal protections beyond just criminal trials. And it could be used in legal challenges where the government places an unfair burden on individuals in civil or administrative matters. I'd like to make reference to three amendments to the New Hampshire Constitution. Part 1, Article 2 in natural rights. It was amended in 1974 to add equality of rights under the law shall not be denied or abridged by this state on account of race, creed, color, sex, or national origin. Part 1, Article 2A, the bearing of arms, was added in December 1st of 1982. All persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. And one of the, I think the most important one that was added recently was Part 1, Article 2B, the right of privacy. An individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. As you hopefully read in Honorable Dan Itz's testimony, our Constitution is very clear. In criminal cases, Part 1, Article 15, no subject shall be arrested, imprisoned, spoiled, or deprived of his property, immunities, or privileges, put out of the protection of the law, exiled or deprived of his life, liberty, or estate, but by the judgment of his peers or the law of the land. The law of the land is the common law. An example of why this is needed. During the late 20th century, child protection was moved out of criminal court and into a civil court. Then, in 1995, a dedicated equity court, civil court, for this purpose was instituted. This is where everything went wrong. The common law foundational law maxims are nowheres to be found in our family court system. These maxims of common law were intended to protect individuals against the overwhelmingly power of the state, are suspended, and they're basically suspended in family court. The jurisdiction of family court 490D3 states explicitly that nothing shall require the facts to be framed by rules in equity or according to the common law. Today in our state, children are being separated from their parents, parental powers and rights being terminated without an ounce of the cornerstone in our judicial system. The cornerstone being innocent unless proven guilty. Evidence that is being supplied to prove innocence or intended malice from the plaintiff/state is frequently brushed aside, ignored, or flat out refused by the courts. There is no greater liberty issue than of your own life or your children's lives. We need to put this element of common law reserved for the people into our Constitution, so it is beyond legislative meddling. Our only job as representatives is to protect the rights of the people. We took an oath to both the New Hampshire and U.S. Constitutions to do so. We work for the people and only for them. Many in the legislature have forgotten that this is our only job here. So my question to all of you is this: do you believe that people accused by the state in criminal or civil court are innocent until proven guilty? If the answer to that question is yes, please pass this in your committee. If the answer to that question is no, Are you willing to tell the people of New Hampshire that the state can accuse them and they will need to prove their innocence rather than the state proving their guilt? We learned a lot from the recent Supreme Court decision. It was the Bruin decision that came out in June of 2022. Bruin marks a return to the general law approach, common foundational law, under which courts look, quote, to history and custom to understand the right. For example, under this view, legislatures could not create sensitive places that effectively deny people their constitutional right to bear arms outside the home. The historical litmus test is important in this issue, and we've seen the courts move in that direction for the last 2 to 3 years. I thank you for your time, and I'm welcome to take any questions.
Questions for this witness? Yes, Representative Horrigan.
Yes, thank you very much, Mr. Chair. Thank you very much, Representative. On the one hand, this amendment is very timely, given what's going on nationwide, some pretty dramatic stuff. But on the other hand, we're a year early because we can't vote on it until November 26th, and also don't. So that means are you intending for us maybe to take some time to think about exactly how to word it? Like, for example, I'm not quite sure what this phrase "one of the people" means. So, can you maybe elucidate like what one of the people is, and then maybe thanks.
Throughout both constitutions, it talks about the people versus and natural rights of the people versus the government. So I think that's what basically the Constitution is written for the people and for their rights to protect, of course, government encroachment. I do know that this falls under voting in 26, and I'm just getting a jump on it.
Thanks.
Other questions for this witness? Seeing none, I guess I have a couple of questions. The first question I have is, can you give us any, you say, for example, if I'm understanding correctly, that in the family courts in child abuse cases, the courts are, am I understanding that you're saying the courts are placing the burden on the person who's accused of having committed some kind of abuse to establish that they're innocent?
It's not just in abuse cases. It could be in custody cases and things like that. So yes, and that is definitely happening. And I can give you multitudes of examples.
So here's my question. I'm just, when I heard of this amendment coming up, I went, did a little research, and I'm looking now at the abuse and neglect statute, and I refer to RSA 169C13, which says the petitioner, that is the state, or whoever is filing to, to say that a child has been abused, has the burden to prove the allegations in support of the petition by a preponderance of the evidence. So I guess what I'm really not clear on is, if you're saying that courts are not following the current law, which very clearly says that the burden is on the state, I guess my question is, how is this going to help? If we pass a constitutional amendment, why won't they ignore that too?
It's just one step in the many, and I think that hopefully with the historical content of how things are being used now, that this could be referred to going up to a higher court level, maybe even out of our own court jurisdiction, that we can use this in a federal manner. There has been unbelievable amounts of evidence that's refused. I'm working with a constituent right now, and every single thing, he just had another hearing, was ignored. The judge decided he wasn't going to look at any of it, none of it. He hasn't seen his children in almost a year, and there's nothing. There's no restraining order. There's nothing against him. It doesn't make any sense.
So can I just ask you, and the information that you've just relayed to us about this case, this constituent or whatever, did you talk to the other side of the case? In other words, you've got, if I'm understanding correctly, you've gotten the perspective of one side of the case, and it sounds like from what you're saying, presumably the side that didn't prevail. So my question is, how are you able to make an accurate assessment of whether that's true if you haven't talked to the other side of the case? You haven't heard what the other side had to say.
This isn't about me taking sides. This is about literally not using the evidence at hand, it being ignored. That's the reason
And
why.
my question is, how do you know that it was ignored?
I've read the court transcripts. I was there, and I was there at the court hearing.
Okay, and so
I watched it firsthand.
did the judge give a reason for why he was not or she was not hearing the evidence?
No, she did not.
Okay, all right. And you say that this is something that has happened routinely.
Multitudes of times.
Okay, all right.
And I will give you whatever you need. I will spend the next 5 days providing all of that information for you.
I would appreciate it if you could get. You say you've looked at the transcript. I would appreciate it. I'd like to see the transcript if you wouldn't mind providing it.
Okay.
All right, great. Other questions for this witness? Seeing none, thank you very much.
Thank you.
Are there any other witnesses who wish to be heard on CACR 7? Seeing none, I'm going to close the hearing on CACR 7. And I think we're probably,
Representative Potenza. Do you have, is that written testimony that you can submit? That would be lovely, thank you. Yes, that was a lot of information for the clerk.
all right. 7, all right, 10 a.m., 6,
Good job.
666,
No one more qualified than you.
666.
I know,
Choice of words.
it's a real test of our ability.
All right, 6. Yeah. All right. You know what? All right. So let me ask you. We have about 5 minutes. I'd like to, while we have that time, turn to and open an executive session on House Bill 480. That was the bill that we heard last week was Representative Pearson testifying. It's the bill that would establish what is the name of it? It establishes a procedure for restoring competency, and it calls for the pilot program to establish in either Merrimack or Stratford County to establish a forensic liaison position to assist in restoring competency. I think when we had a brief discussion about it last week, Representative Peternell had a question about, wanted to sort of look at it a little bit further. I think she's now as I understand it, had the chance to do that. So it seemed like we were all generally in agreement on this, with the exception of the concerns Representative Peternell had. And my understanding, and I'll let her speak for herself, is that she has satisfied her concerns and is now okay with it. So if we are all generally in consensus, I would propose to exec the bill and take a vote on it now. Is there anybody that has a problem with doing that?
I have no problem at all. We do have a quorum. My only question is, since there are only 11 of us, do you think, and it is a quorum,
Right.
assuming Joe comes back,
Right.
do you think that it would be better to have more people here? And
Yeah.
I'm not prejudging the answer. I'm just raising the
Yeah.
question.
No, I hear what you're saying. I guess my sense is that, when we did have more some people who are not here today, my recollection is nobody had any issues. So
I agree with that. And for example, Representative Turer, who is not here because he's at another important legislative-related meeting, was actually on the.
That's right. He was on this. That's right.
And is a sponsor of the bill.
And I believe I believe Representative Kutab was, if she was not, she was either on the committee or certainly is
And
very
she's a sponsor too.
intimately familiar with it. So I don't think, so given those,
Me to go ahead, and I don't see any of my colleagues expressing any concern.
All right.
I do want to mention that we have received an email from the Disabilities Rights Center
right.
saying that they felt that they had not been included. And I read it and I understand what they said, but I'm not sure that, other than recognizing their absolute right to have expressed their concern about that it in fact affected the outcome.
Right. No, that was my sense too. But Representative Rambo.
Representative Smith covered what I wanted. I just wanted to mention the email we had all
no,
received.
I saw that also, and I
didn't know if there were any concerns about that or.
right.
Yeah.
It seemed to me. I mean, I obviously I was not a member of that subcommittee, but it really did seem to me, both from Representative Pearson's testimony and just discussions that I've had with Representative Kutab, that there was Representative Pearson tried to get the broadest possible input from various factors, various places, and it seemed like he achieved that. So unless anybody has any strong objection, I would propose to, yes, Representative Andrews.
Thank you, Mr. Chair. I have a strong objection. In executive session, normally, when we advertise it, we make sure we have 20 people here. And today we have 8 missing. And they may all be in favor of the bill. But I just don't think it's fair to exec a bill with so many of us missing. And if we're going to exec bills, then maybe we need to fill the chairs with the, appropriate substitutes. That's just my opinion.
Okay. Well, does anybody else have that? If anybody, yes, Representative Bergeron.
Thank you, Mr. Chair. I have a very broad question. I'm not exactly sure who to ask, but at this point in time, if a bill like this, and I'm not sure what your thought methodology is, but when a bill like this happens and all of a sudden it takes, like, everybody starts reading about it, and what if it becomes this big deal? I mean, does legal look at these so it's okay, or we're legal? Because I know on other places I've been, it's like we do our thing and then pass it to legal to make sure it's worded correctly or whatnot, so we can't get in trouble. But I was just confusing. Yeah, I was just curious if that's a part of the procedure is having. I know we don't have attorneys kicking around. But.
No, go ahead, Representative Smith. I'll let you.
Good question. The legislature makes the law. And there are times when the legislature isn't 100% comfortable. And although I don't agree with this, they then go through what I refer to as mommy may I, and that is to ask the Supreme Court for a decision as to whether X, Y, or Z is appropriate. Other than that, we make the law. And so, and we, when the bills are drafted, there are all kinds of people whose advice is sought, but, so it's a little different from another environment.
I appreciate it.
All right, so let me ask if Representative Andrews has expressed some concern about doing this. If that would lead Representative Andrews to vote no, that would be a 10-1 vote, which would still be sufficient.
You can vote. I just want to give my opinion.
Yeah, no, I hear you. I guess what I would say, Representative Andrews, is this: I would not do this if we had not discussed this last week, and the people who are missing did not express any objection to proceeding. But it seems to me, given that they didn't, and that the only person who had a concern, and a perfectly legitimate concern, Representative Petronil, has now studied the bill, and her concerns are resolved, I think there really is an interest in proceeding. And I guess, one of the things that I think is really important to emphasize is, I think not only today, but going forward with the rest of the days of hearings, it will be really important for this committee to try to exec as many bills as you can exec, as quickly as possible, because in early March, we're going to have a lot of work to do. And to the extent we can, remove bills early, I think it is in everybody's interest to do that. Representative Petronil.
Thank you, Mr. Chairman. I just wanted to speak for myself that, yes, I have had an opportunity to review this amendment and I'm in support of it. However, I'm looking in my bill file and I noticed that we don't have a member of the committee whose name is on this amendment. So we would need to have that, I believe, before we can actually introduce and vote on it. It's Representative Pearson's. No? We
No,
can
any-
offer?
any-
Okay,
any
sorry.
member of the committee
All right,
can offer.
all right.
So I guess I would propose to go ahead with the executing on this bill. And so first, I will move amendment,
But first you have to move OTPA.
right. I will move amendment 2025-0061H as an amendment to House Bill 480. And is there a second for that?
I second it.
All right. So,
But I believe your motion was OTPA,
I'm sorry, OTP, yes, it was.
which I second.
All right.
And then you'll submit the amendment.
Yeah.
Page. I'm
Yes,
sorry.
and so all right, so the motion has been made and seconded on the amendment. And can I just ask for a show of hands of all those in favor of amendment 2025-0061? Please raise your hand. And this is like unanimous, 11-0. I thought, Representative Anderson, I thought you did raise your hand. Did I? Yeah, okay,
Yeah.
yeah. All right. All right, and so we're now then on to the main motion of ought to pass as amended. Anyone wish to be heard any further on that? All right, seeing none, I would ask the clerk then to please call the roll on the motion being OTPA on House Bill 480 with amendment 2025-0061H.
Representative Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews.
No.
Clerk votes yes. Representative Smith,
Yes.
Representative Horgan,
Yes.
Representative Page,
Yes.
Representative Rombo,
Yes.
and Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
10 yeas, 1 nay.
All right, so the motion carries. Since I was up early this morning and actually have the report written, I'll write the report.
You made the motion. So you can write it.
Right.
You were going to ask me to write it. That's
No.
not fair.
All right.
No, not consent.
Is there,
Representative Andrews says no to consent.
no, all right, so it will not, I don't know that it would go on consent anyway, because it is, even though it's not a money bill now, it is gonna clearly go to finance, so I think we're better
Okay.
off not having it on consent anyway. Representative Andrews, do you plan to write a minority report? No. Okay, all right. All right, good. Good. Well, thank you. I'm glad we at least got that out of the way, and I know Representative Pearson will be happy about that also. All right, next, we're on to after 10, and I'm going to open the hearing on House Bill 666 FN relative to adding restitution payments for violations of the confidentiality of the library use records and adding library cards and membership status to the list of confidential matters. And I recognize Representative Potenza. Oh, I'm sorry, Representative Mazurs, I'm sorry.
Thank you, Mr. Chair and honorable members of the committee. Good morning. For the record, my name is Lisa Mazur, representing Hillsborough District 44, Goffstown, and Ware. I'm going to start by saying don't hold the bill number 666 against me. I did not ask for that. I could not change it. So, all right. So first of all, thank you for passing HB 376 on consent last week. That was a big privacy win for present and future library users, not only in Goffstown, but throughout our entire state. So that bill, this is part 2 of that bill. So that bill addressed expanding 91A:5 to clarify that library cards and library membership statuses are exempt from right to know requests. This bill addresses RSA 201D:11, which pertains to the confidentiality of library user records. Currently, the RSA language reads, and I quote, "Library records which contain the names or other personal identifying information regarding the users of public or other than public libraries shall be confidential and shall not be disclosed. Such records include, but are not limited to, library information system and archival records related to the circulation and use of library materials or services, including records of materials that have been viewed or stored in electronic form," end quote. Again, it appears the current law is pretty straightforward in keeping library cards confidential, but our town apparently did not think so. So this further clarifies that. This bill copies the exact same verbiage as 91A:5 to read, "Such records include but are not limited to library cards and library membership status, etc." for consistency. This bill also adds a restitution payment as a penalty for violations of disclosing this private information. Adding restitution as a remedy ensures that individuals harmed by such breaches have a clear avenue for relief, which the people in our town did not. Financial penalties also serve as a deterrent, reinforcing the seriousness of protecting library users. Libraries are cornerstones of intellectual freedom and privacy. Patrons must feel confident that their reading habits, research inquiries, and membership status remain confidential. The current law provides some protection, but additional measures are needed to deter violations and address harm when breaches occur, which the current law does not. By extending confidentiality protections to these aspects, we align library privacy standards with broader protections for personally identifiable information. I urge this committee to adopt these enhancements to safeguard the privacy and trust that are fundamental to the role of libraries in our communities. Thank you for your consideration, and I welcome any questions.
Questions for this witness? Yes, Representative Rambo.
Thank you, Mr. Chairman. Thank you for taking my question. For the restitution, for the new paragraph, is there any intentionality or knowing sort of, or did you contemplate including that kind of language in terms of?
This was actually done through our drafting attorney, and so he went through the proper recourse to decide to figure out an amount that would be not a financial liability to people, but also, as I mentioned, a deterrent.
Yeah, so I'm sorry,
Yeah.
I don't think I asked the question very clearly. I meant if there was an unintentional disclosure, how does that work with the restitution fee?
I'm not sure what you
Or
mean.
is it a penalty in terms of like a knowing disclosure as opposed to someone accidentally disclosing? Are they still liable for the?
How would you accidentally disclose a library card?
I mean, I can, I'm just spitballing here, but like some sort of data breach, some sort of something, some sort of record keeping error in an office, or I think there's scenarios I could imagine. So I just.
So a data breach, a GDPR breach, I believe, is a whole different situation. This is someone intentionally filing a right to know to request and publish someone's personal private information. And in the case in our town, they were weaponizing library
You're saying
cards.
because it's part two of falling under the right to know
Yes,
umbrella. Okay.
exactly.
Okay. All right.
Yes,
I appreciate
this,
that.
yeah.
And then my other question. Oh, sorry. I can't do that. Sorry.
Do you have
Yeah,
another
so-
question?
I do have one. It's a very narrow
Go ahead.
follow-up, if
That's
you don't
fine.
mind.
Go
Thank
ahead.
you. Where you cross out or where otherwise required by statute. Can you tell me about striking out that part?
Yeah. So there's other places in statute where library cards can be released via court order or if someone's under investigation. So that's another area of statute. So this would say that like if that pertained, then this doesn't apply. So you can get someone's library card. Someone can come in if they have something going on them that the law needs that information. Yes. Yeah.
Representative Smith. I'm sorry, Representative Bergeron next.
Oh.
Thank you for being here and your sense of humor. I just wanted to know, as far as like education, for example, we have so many with schools. Does any of that apply to the kind of privacy that students like in their school? Or
Thank you for that question. I wish it did. This law specifically, this RSA 201D:11 specifically addresses confidentiality of library users. So I don't believe that's the public school library. This is public, pertaining to public libraries, like town libraries. So I don't have the answer for the schools.
All right, Representative Smith.
Thank you. Thank you very much for explaining this to us. Do you see any exceptions other than those that you identified for that are already noted in the RSAs to this? Does this apply to everyone?
Yes.
Thank you.
Children, adults, yes.
Thank you.
Representative Horgan.
Yes, there is a reference to a court order in part 2, but that's a court order explicitly allowing the library card uses to be divulged. But how do you prove that the information was divulged without consent of the individual, and how do you prove who did it? And how did you arrive at the fine, which seems like a fairly excessive fine, so it might dissuade people from volunteering at their local library if
Okay.
So how?
Can you
So-
start with your first question?
Yeah.
And then I'll.
Yeah.
Okay, what's the first one again?
Well, how do you prove? What's the procedure for proving that this happened? That this information was in fact actually divulged, and then who divulged it, and then also like. Okay. So
Well, I'll just give you the example that happened in our town. A right to know was filed by the wife of our select board chair. And we didn't, the people that it happened to, all 6 library candidates actually had no idea that had happened, except that the next thing we knew, they were all over social media, the library cards. So the candidates were, how the heck, what is happening? So the candidates, or one of them, filed a right to know with the library saying, how did this come to this? That's where we found out who had filed the original right to know for the information. Our select board's chair's wife had requested them. So that's how we found that out, through a right to know. So what's your second question?
Well, you actually have a follow-up to the fine. That seems like an excessive fine, but also you raise the question then, is there an exception for in the context of a political campaign? What if you have like very contentious campaign for library board trustee and somebody accuses one of the other candidates of not having a library card? So can that could that lead to the candidate being fined?
I believe someone brought that up in the hearing last week. So let's say someone runs for budget committee. Can we ask for someone's bank card to prove that they have some sort of handling of money experience? I mean, in what other areas are we asking people to prove something with using their private information to do so? It was mentioned that if people want to, come up and ask a candidate, if that's the case, then that's their prerogative to do so. But publishing it all over the internet and everywhere else is not the way.
Okay, can I get back to my
Right. Other
original follow?
question, Representative Mannion. Representative Mannion.
Thank you, Mr. Chair. Thank you for taking my question. So we heard earlier about a bill about parents receiving information on minor child's library information or status. Is that outside of this bill? Or is that outside of 91A, that first
Yes,
bill? You familiar with it?
absolutely.
So that would be exempt from this?
Yes.
Okay, thank you.
Yeah, that's a whole different thing.
Other questions for this witness? I guess I have a question on with regard to Section 4, the penalty provision. I have no problem with it saying any library or library staff member. I guess I have some question about any member of the public. In other words, am I understanding that this would mean that if I, as a member of the public, know from somebody telling me or whatever, that you have a library card, I'm prohibited from saying to anyone else, Representative Mazur has a library card? Why?
Well, publicizing it. So, I mean,
But it says discloses. So,
Yes.
So discloses could mean I tell Representative Horgan, I've disclosed it.
well, I don't think that's appropriate to do that. And in the case in our town, it was a member of the general public who submitted a right to know and then published it all over the internet. She disclosed that private information without our consent. It's one thing if you give consent to people to do that. That would be like, disclosing any other private information that you told someone in confidence and then they're putting it out to the world.
Right. I mean, I guess what I'm getting, I guess what I understand what you're concerned about with the right to know. And I think we've probably addressed that with the other bill that we've, to say you can't, that's going to be confidential information. But what I'm saying is this seems to me to say that I can't, however I got, for example, you might suppose that, your husband, daughter, relative tells me in the course of casual conversation that you have a library card. And I tell Representative Horgan, this would seem to me to say that I could be held liable for doing that.
I mean, if the committee would be amenable, I can change that disclose word to, who publishes, publicly publishes information. But
I guess my concern is just basically the idea of saying any member of the public.
yeah, because that's what happened in our town. And it went viral, those cards. And there were people.
Is there a First Amendment issue here? That, in other words, a member, you're telling me that as a member of the public, I haven't gotten, I haven't broken into or made an improper 91A request or anything. I'm a member of the public, and I have information that you have a library card. Is there a First Amendment problem with your
Absolutely
saying
not.
I cannot tell somebody?
This is a privacy issue.
But if I know it's no longer private, I know that information.
Well, now that's the case in our town. Everybody knows who does and who doesn't. It's to prevent that in the future because it's, let's say this is a silly analogy, but let's say someone running for budget committee, stashes all of their money, under their mattress versus utilizing a bank for it. And someone knows that information. Like, I guess that could, go wherever it is, but it just, I don't know. It just, Representative Alexander, do you?
Sorry, Representative Alexander, did you
Thank you, Mr. Chair. Would the sponsor be amenable to an amendment that would drop Section 2 and just maintain Section 1 to clarify. So drop the penalty, because I think that was where a lot of the questions are coming from, and just leave section 1. Would the sponsor be amenable to that?
I would be amenable to that. It sounds though like that it's just that word who discloses, that discloses word.
Yeah, well, you know what? I mean, I guess what I would say, I don't have any problem. I mean, I actually think that the idea of having some kind of a penalty is probably a good idea if you want to, you know. But my only concern was how broad it would be, because, you know, the analogy that I would draw is this. I know in many states, and I think it's true in New Hampshire, if somebody can correct me if I'm wrong, whether you have a pistol permit, even though you don't need one anymore, you can still get one. Whether you have a pistol permit is the police are not supposed to disclose that, right? But if I know from some source that you have a pistol permit, and I tell, you know, Representative Bergeron, oh, Representative Missouri has a pistol permit, can I be held liable for that? If I didn't get it, I didn't get any, you know, I didn't break into and take any confidential information. I just know that you have a pistol permit. That just seems to me to be awfully broad prohibition.
I think I'm just a staunch defender of privacy. And this, what we experienced in our town, and there are many on both sides of the aisle that agreed that this was an egregious breach of privacy, especially publishing them all over the place. I guess it's, but then it is, if, you know, you keep going down this path and it's just people will then just start, this will become just a thing in our elections and beyond, that people start weaponizing private information to win elections. And this is just not the way. This is just a small step in trying to have that not happen again. And by putting a penalty on it, because right now, what's the repercussion of it? Nothing. A little slap on the hand, big deal. We'll just continue to do it again. So that was this. If you would like to amend it in a way that makes it more zoned in on just the library card versus membership status, that's a possibility as well.
Representative Alexander.
Thank you, Mr. Chair. I'm happy to, while you're traveling in Southeast Asia, workshop this bill and get it to a good point, if that's what you prefer.
Yeah, no, that'd be great. Other questions for this witness?
I just want to,
Representative Smith.
thank you. I just want to point out how easy it is to share information that perhaps isn't necessarily public. For example, where one person or another might be traveling.
Right. All right. I don't see any other questions. Thank you very much, Representative Missouri. So you know what I would say, Representative Alexander, is the things that I would obviously the subcommittee can do what it pleases and it'll come back before the committee. But what I would suggest it would be appropriate to think about would be perhaps just removing the reference to a member of the public, number one. And the second thing that I would suggest you might want to think about is restitution in the law has a particular meaning. It means you've been harmed, to give you back a something that you've lost. And I would think, as you said, I think a couple of times in your testimony, Representative Missouri, this is really intended as sort of a civil penalty. So I would say it might be better to just refer to it. Instead of saying restitution, refer to it as a civil penalty, a $500 civil penalty.
Can I just, something you said, it's to address something that someone's lost. Right. Well, many people have lost trust through this process. So yes, something was lost in this breach.
Yeah, I'm not sure that would be the kind of thing that you could measure to, I think it really, isn't the idea here to sort of a sanction? It's not, I mean, even if the person, suppose in the example, the person, actually who was disclosed not to have a library card won an overwhelming victory in the election for library trustee. I mean, do you want to say, well, no, you didn't lose anything. You actually, you you won a slam dunk, an overwhelming victory. You'd still want them to pay to have to pay, wouldn't you? All right, so that's why I'm just saying it might make more sense to call it a civil penalty, because that's kind of what it is. And I wouldn't have,
Yes, and
personally, I wouldn't have any problem with that.
Yeah, and
Calling
it
a civil
wasn't
penalty.
just myself that it was, there were several other people that were involved in this, and there was no course of action that there was nothing that could be taken. We tried the ombudsman thing. That was 6 months of wasted time. And then we're not going to pay a lot of money for a court action when in our the current law to us seemed so clear. So this just tightens it up. And we heard from Right to Know New Hampshire in the last hearing that they agreed that they can't believe that clarification is needed on this, but apparently it is, and they agreed with that.
All right. Other questions for this witness? Oh, yes, Representative Hoare.
I would just chime in very quickly and express the opinion, or I guess it's okay to do so now, that $500 might be an excessive penalty for this violation too. So we want something that's not so large that it will start dissuading people from taking a low-paying job at the library or being a volunteer or so forth. They're just,
Fair point.
If
Fair
that was
point.
I'm sorry, if that was a question, I'll say, no, that's to dissuade people from releasing people's private information. That's what that is.
but it might have it. Okay.
Okay. All right. Yeah, we want. I think we don't want to have a debate here on that. All right. Any other questions for this witness? Thank you, Representative Missouri. Are there any other witnesses who wish to be heard on House Bill 666 FN? Seeing none, I'm going to close the hearing on House Bill 666 FN, and we have a couple of minutes. I'm going to open the hearing on House Bill 687 FN. Hang on one second, and recognize Representative Corcoran, the prime sponsor.
Thank you, representatives. So this bill is pretty simple, and best of all, it has zero cost associated with it. And what it does is just put in restrictions on where funds from class action settlements can be directed. This is a problem that my research has shown hasn't been too much of an issue in New Hampshire, but is in several other states and has been at the federal level. Often there will be a situation where a class action lawsuit is driven not so much by huge claims to the plaintiffs, although there are certainly going to be some claims, damages, or it wouldn't get anywhere, but are driven largely by lawyers, sometimes lawyers associated with an activist cause. So one example might be that milk has been mislabeled. It's been labeled as 4% fat, and it's actually 3.92% fat, and testing has shown this. And the attorneys and the activists will go out sort of effectively shopping for a plaintiff class, and they will either find 500 people to sign up or have their activist list of people who are always happy to say, yes, I bought a gallon of milk and I feel that I was damaged by not getting the full percent of butterfat. The damages in such a situation might not be, hugely quantifiable, but there'll be some number arrived at, and then the courts will often not want to cut checks of 2.3 cents to each of 10,000 plaintiffs, and the attorneys will say, oh, of course you don't. The overhead on that would be outrageous. Let's do something useful with this settlement. The $100,000 of settlement should really go to the Vegans for Farm Law Reform, or something like that. And you can picture this in various directions. It's not necessarily a left-wing activist. Right-wing activists can do this as well. And the intent of class action lawsuits is good, where any one person has some degree of harms. There's radon in my basement, or there's a defective bumper on my truck, and I did in fact suffer $200 of damages from this. But it would never be worth $25,000 in attorney fees to right this wrong. So the intent of class action lawsuits is that by consolidating all of these cases and consolidating all of the harms, but only going through one lawsuit, that sort of justice is arrived at without a huge amount of friction. And the intent of this sort of minor clarification, which brings us in line with a few other states that have such things, is there can in fact be such lawsuits. These are a good, useful tool, but we want to make sure that the actual intent of a class action lawsuit is achieved, and not some other intent that's sort of riding in the form of a legitimate class action lawsuit. And I would invite any questions.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you for your time.
Is there anyone else who wishes to be heard on House Bill 687? Seeing none, I'm going to close the hearing on House Bill 687.
Could I ask a question of anyone who might be a former member of the judicial branch?
Yes, you may.
Thank you. Would you, I read the definition of cypress. Not being an attorney, could you explain to me the relevance in this legislation?
Yeah, I think, I please understand, I don't profess to be an expert on cypre either, but
Pray.
I think
I
I think
said
it's
press.
I think it's
okay.
I
Thank you for
think it's
that. Now I've
cypre.
learned something. Good.
But basically, I think it is a judicial doctrine that's been around, I think, really for centuries, and it allows the court. Let me give you an example which comes to mind. You may remember the Youth Development Center.
Oh yes.
I think it's the Youth Development Center. I think I've got that right. So the originally the land that was on was donated to. I'm either the city of Manchester. I'm not sure who, or the state. Or it was donated for certain purposes to be used for and I'm just making this up because I don't frankly remember, but they're to be used for, let's say, to be used for the establishment of a school, let's say. And let's say for one reason or another, there is no longer a need for the school. In other words, there's, the educational needs of the children of Manchester are being taken care of in other ways. This would allow a court to say, well, okay, I'm going to allow the trust that established this to be changed, the terms to be changed to something that, satisfies the more general intent of the person who made the donation. That, I think, that maybe is a bit of an oversimplification, but that's kind of generally the idea.
Thank you. Thank you. I appreciate that. Since we're just informal, I would say that when I was chair of finance a long time ago, I wanted to close YDC because of Susan, because anyone who knew anything about what was going on. No, because we're not in.
Are we in recess or is this public?
Well, we are, no, we are in, we're open. I should. Something we might want to consider when we get around to executing the bill is it the role of us, the government, to tell people in private litigation what their class action settlements should be? If the parties, I just raised the question. Maybe the answer is yes, but I just raised the question. Anyway.
Oh, yeah, maybe.
Nobody's here. McFarland
All right.
Perez and
Let me just see about this.
You hear the buzzing? Yeah. You gotta come over here. It's like a whistle. Yeah.
Impact.
Come
All
right,
right.
right.
Third Bank of Lights. Could be.
One right here. It's right next to my house.
Disparate impact.
Would you mind just climbing up on,
Yeah.
fixing it? I mean, you do everything else for us. Why wouldn't you do that?
Yeah, I have a headache.
Do you need the nurse or anything? Or the nurse? I have the number.
Thank you. I'm good.
11:15. Yeah, yeah. We're in recess till 11:15, and I'll turn my. on House Bill 369. And I'm going to recognize, Chair recognizes Representative Kutab to introduce an amendment.
Thank you, Chairman Lynn. I'd like to move Amendment 2025. A move ought to pass on with Amendment 225-0167H.
And I second that.
All right, so
And now you're going to talk about the amendment.
And the amendment is simply changing on lines 24 and 23. It's changing that with a victim less than 18 years of age on both of those lines, rather than saying 16 years of age or under, or less than 16, and making it two different numbers there. So less than 18 years of age, that's all the amendment is doing. And I did run the amendment by the prosecutor who's here, Attorney Enders, and he was in agreement that the amendment would work.
right, and as I understand, this is an amendment that was jointly proposed by you and Representative Tur. Is that correct?
That is correct.
And so, again, my recollection from our discussion of, I think it was last week, was that this was the only issue that, sort of was any, that anyone had any problem with, and that otherwise it appeared that we were all generally sympathetic to this bill with the amendment. Am I incorrect in that? Does anybody have any issue that, any reason that we shouldn't exec it now? Representative Andrews.
I'm going to go back to the same thing. I'm going to vote no because I think we need 20 people here to vote on this bill.
We only have 18 on the committee, so.
18. Sorry about that.
All right. I appreciate your position, Representative Andrews, but I think given the circumstances here, I disagree with it. So I guess I'm going to first then call for a vote on the amendment, and I think we can do that by a show of hands. So to ask all those in favor of Amendment 2025-0167H, please raise your hand. $11. Did I count that right? Yes, 11. Okay, 11. And all those opposed? All right, 11 to 1. Amendment. All right. Vote is 11 to 1 in favor of OTPA. And now on the Representative Katab, I'm going to call upon you again. Do you have a motion, OTPA, on the main motion?
Yes, I move OTPA on House Bill 369 with the amendment we just passed.
All right, is there a second? Oh, all right, seconded by Representative Smith. All right. Anybody else have anything they want to say before we vote on the main motion? Seeing none, I would ask the clerk to call the roll on the motion is OTPA on House Bill 369 FN with amendment 2025-0167H.
Representative Mannion,
Yes.
Representative Alexander, Representative Tripp,
Yes.
Representative Andrews,
No.
Representative Kutab,
Yes.
clerk votes yes. Representative Smith, Representative Horgan,
Yes.
Representative Page, Representative Rombo,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
11 yeas, 1 nay.
All right. So this will go on the let's see. Yeah, this is an early bill. Yes, so this will go on the regular calendar. Representative Kutab, could I ask you to prepare the report?
I'd be happy to.
And do you think you could do that by tonight?
I'll do it now.
Oh, that'd be great. Thank you. All right. Will there be a minority report, Representative Andrews? Yeah. All right. All right. Can I have it by tonight? Okay. All right. Sure. Yeah. All right.
Just for your information, Representative Manos has signaled that although she knows it doesn't count in the vote, she supports what we just heard.
Okay. Oh, all right. Good. All right. All right. So now I'm going to open the hearing on House Bill 697 FN. And 697, hang on. Let's see. Oh, sure. Representative Kutab, do you want to introduce the bill, if you would, please?
Thank you, Chairman Lynn and members of the Judiciary Committee. For the record, I'm Representative Caitlin Kutab, and I am introducing House Bill 697 on behalf of the prime sponsor, Rep. Potenza, who couldn't be here today. This bill allows witness fees for criminal proceedings for civilian witnesses who appear in court to testify, and it is giving the same rate of fees as those federally authorized.
All right. Any questions for this witness? See, I don't know whether you're in the position to answer this, but can you, I should know this, but it's been a long time since I was in federal court. So what is the witness fee under 1821?
I think it's like $35. I think currently we have it as $35, and we're in. Let me just check what. I don't want to give you an hour. Give me 1 second. Let me look and see what it is now and what it would be going to, just so I. So we actually repealed that witness fee part. So. $40 per day.
$40 per day is the witness fee in federal court.
Correct.
Okay. All right. And hours, you said, I think where I remember from last year that we had repealed, or and I'm not sure if we did it, but there was no witness fee stated. Is that right?
It got repealed. It used to be $12 for a half a day.
Okay.
It was repealed in 2019.
Okay. All right. Anybody else have any questions? Representative Smith. Oh, Representative Bergeron, you go first, then Representative Smith.
I just have one question. When I see the word entitled to a payment, does that mean that that could just change on constituents? Because it just says payment. It doesn't say an exact amount that can be adjusted if in the event that the cost is adjusted. Or do you think we should just leave the word, it shall be entitled to a payment, and that's all it says? It doesn't have like a.
I'm not sure where you're seeing entitled to a payment. Oh, entitled to a payment for each day, but it gives the rate of the fee shall be the same as those authorized in 28 USC section 1821 as the last sentence.
Okay, perfect. Thank you.
Representative Smith.
Thank you. I'm confused. This seems to apply to when someone has to come back again for reasons that are no fault of their own. What happens when they're there the first time? Do they get reimbursed?
I think the answer is no. I think.
To my knowledge, they do not. and I would be happy to pay them both times, but I think she was at least trying to take a bite of the apple, particularly for the cases that are really far away. People are taking time out of work and driving sometimes quite a bit of a distance to get there and not receiving any payment.
And could I follow up?
Of course, yes.
Thank you. And does the fact that we don't reimburse the first time explain why we are using not a state rate, but a federal rate because we have no state rate?
I believe that to be the case.
Thank you.
The only other question I have is, should we be, if we pass the bill the way it's worded with that reference to the federal statute, should there be any concern, should we have any concern that if the feds, which have not been known to control spending very well, decide that they're going to increase the rate to $100 a day or something like that, that then we will be on the hook to do the same thing?
Well, I should hope that with this bill, we will make a much better effort to ensure that we don't have witnesses driving in for cases that are not then going to be heard, because I would hope that the reason why we're having people come in should be a pretty limited circumstance, and that we should know ahead of time that there's been some extenuating circumstance or whatnot. So I'd hope that we would just do a better job to not have this happen.
Representative Smith.
Thank you. Representative Kutab, what would happen if in the fullness of time, the federal government would decide that it will no longer pay witness fees, and would that then mean that we would not be paying a fee that we think is appropriate to pay?
I suppose that could happen, just as it could happen that we reference with in the state rep statute for us to get federal mileage reimbursement, that they could come back and decide we're not going to pay federal mileage anymore. So I think it could happen. Hopefully it doesn't.
Representative Tripp.
Thank you for taking my question. You mentioned that you hope that you wouldn't have people driving in to testify at a case and then not having the case heard. Is that something that happens frequently?
I'm not sure of the exact frequency, but it definitely does happen. It happened in the case of the prime sponsor who put in the bill. And I do want to note that the federal rate was set in September of 1996 and has not changed since. So it's been about 29 years that it has stayed the same.
Any other questions for this witness? Seeing none, thank you. Are there any other witnesses that wish to appear on House Bill 697 FN? Seeing none, I would, I guess before I close the hearing, just so that we're still on the record, one of the things I would say, and Representative Kutab, just in my experience, and Representative Mannion may be able to shed some light on this also. I think it does happen with some frequency that witnesses are have to come back multiple days, because what often happened, I mean, I remember when I was a prosecutor, it often happened that I would have more witnesses than I needed for the particular day be there, because if somehow a witness took less time than I thought and I ended up with no witnesses, the judge was going to be yelling at me, why aren't you, why are we wasting all this time? Because, we're not finishing up today because you don't have any witnesses. So in order to, once you've heard that a few times, and frankly, when I was a judge, I think I would probably have done the same thing. You've set aside some time for trial. You expect the sides to have their witnesses there. And since it's not in any way an exact science, what most good lawyers will do is make sure that they're not going to run out of witnesses on any particular day, which may mean that they have extra witnesses and somebody has to come back. That was my experience. I don't know about you, Representative Mannion.
Yeah, I agree with that. We didn't have a lot of cases where there were a lot of witnesses that I prosecuted, but yeah, I agree with you.
All right. Yes, Representative Tripp.
Since we're just making comments, I'd like to comment that I was asked to be a witness at a case one time, and I drove from Derry to probably Portsmouth probably 5 times, and the case was never heard. You know, so not getting paid for the first time, you know, is an issue to me. Thank you.
Sure. No, I hear you. I hear you. Yeah, I mean, I my own sense is I think generally I think the bill is a good idea, but you may be right. Maybe we should, maybe we should be paying, people should be paying for the first time. That you might be right.
Well, if the case isn't heard, does that mean it's not the first time?
Yeah, I think that's I mean, especially if you've been told to be there and then at the last minute the case isn't heard, which happens with some frequency. All right, well, that's something for us to consider when it's time to exec the bill. All right. So now I'm going to close the hearing on HB 697 FN, and we actually have time for lunch.
You must have done something wrong.
I must have done something wrong.
Wait, before you leave, oh, no, you're just doing that.
Given this budget season, I'd be fine with that, but I don't know where we can get more budget in there for that, so I think keeping something is better than getting nothing.
All right, is everybody comfortable if we exec 697? All right, so I'm going to open the executive session, and yeah, sure, absolutely. Take your time. Just let me know when you're ready.
Oh, Kaylee, yeah, that's a great thing. Is this going to finance?
697. I don't think so. Hang on.
Let's say yes then.
97. No, it's not an early bill. No. All right. So HB 697 FN. I'm going to open the executive session, and do I have a motion with regard to House Bill 697 FN?
I move ought to pass on House Bill 697 FN.
All right. Representative Khattab, do you wish to speak to your motion?
I just simply that I think if we're requiring that a witness have to be somewhere, we're subpoenaing them there, they should have some sort of compensation for the time that they're going to be out of work and for the mileage that they're, driving up there. I think it's only fair that if we're requiring that we're taking up their day, their freedom for that day, that we should give them a little bit of money in exchange for that.
All right, anybody else wish to be heard on 697? All right, now I say, as I think Representative Tripp's point about, maybe at some point in the future, we want to consider even for the first time, but as you point out, Representative Kutab, given the current budget situation, maybe it's better to get something for now and wait, and we don't want to let the perfect become the enemy of the good. So anybody else have anything they want to say? All right, so I then ask the clerk to call the roll. The motion is OTP on House Bill 697.
Representative Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews.
No.
Representative Kutab,
Yes.
clerk votes yes. Representative Smith. Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes.
Chairman Lynn.
Yes.
11 yeas, 1 nay.
Representative Kutab, can I call upon you again? Would you mind writing the report?
I'd be happy to.
And will there be a minority report, Representative Andrews?
I have a question.
Yes.
Where I'm doing no on the exact bills,
Yeah.
do I have to write a report for each bill, or should I, for each bill that is, I'm not against the bill, I'm just against the process, or can I do it all on one?
I think you have to do it bill by bill, right? I mean, but you
This-
could say one, in one.
If I could respond.
Sure.
Just because you voted no does not mean that you have to write a minority report. There doesn't have to be a minority report. However, if you are, if you want to make clear your reason is process and not the bill itself, you can do it once and
Name
Oh,
all the bills?
no,
No?
because I do not believe that you can name other bills in a minority report.
Right.
You can only name the bill that you're writing the minority report on. So if you want to make your point, you can make it once and then let it go. But if you want to make it 3 times, you're going to have to write 3 minority reports. And in each case, wait. Right.
Right.
This could go on consent, right? If she doesn't want to write a minority report, this bill could
Yeah,
just
but
go on
wait, but
consent.
the point that I just completely missed that is absolutely true is you would have to have a recommendation. And if you don't want your recommendation to be, it can't be the same as, it can't be OTP in the case of the last bill or OTPA.
Louise, may I?
So you could in fact, I guess you could say retain, which would be a different position and which would indicate that it should come back to the committee for the committee to consider. And your hope would be that it would be with more people present.
Representative Andrews, may I suggest, not that I want to prolong us at House session days, but instead of writing minority reports on all of those bills, maybe say something during unanimous consent about how you voted against these bills because you don't agree with them, with the process. And that might solve your problem where you're able to make the statement, but
Yeah,
you don't disagree with the
I
committee
could do it on
position.
the House floor.
Yeah, that's fine.
Okay.
Sure.
Yeah. And she could do it appropriately could do it as a floor speech on the first of these bills. And then, and I think she
Sure.
can at least imply that she feels the same way about certain other bills that are also going to be on the calendar.
Yeah, no, that's absolutely fine. All right.
So no more, you're not doing, I'm going for either one.
Yeah, there's no sense of me retaining a bill.
Yeah.
I mean, that's crazy. So excuse me, if it's okay, I just won't write any reports and I'll just make a statement on the House floor.
Okay.
So
all
can
right,
we put
fine.
this one
Can
on
we- Can we
consent
put
then?
this on consent then, or?
No, because then she would go to the.
Yeah.
Oh, okay, no, all right.
Well, I thought she's giving I thought she's giving unanimous consent on all three bills at once. So
No,
it's
she's not talking about unanimous consent, When she's talking about when the bill is. Joe suggested unanimous consent.
It's just give a floor speech and then don't do any, and then the voice presumably will be ITL.
So Louise, what if
passed by
only
voice vote.
one of the bills goes on a regular calendar? And you speak against it explaining, you speak explaining what your concerns are, and that it applies to other bills with the same votes.
Okay,
And then you can let the other two go on consent.
that's fine with me.
Okay.
So
all right,
one,
So,
you want the first one in numerical order to go on the regular calendar?
I think 369 had to go on the regular calendar because it had
right, it's
the
an early
fiscal
bill.
note,
Yes, it's an early bill, right.
but the other two didn't. Like HB 697 doesn't have to.
Whichever one is regular, I'll just write a minority, but then I gotta go back to retaining
No, you
it.
don't have to write it minority. So if 369 goes on the regular
Regular calendar.
calendar,
Right.
okay, you then would tell the clerk that you want to speak on 369. And then 480 and 697 could just go on consent. Does that work for people? Both
know what-
in
you know
terms
what-
of
you
you
know what-
making your point and in terms of efficiency.
Yeah, you know what, my only concern, Representative Smith, is even though 480 is not listed as an early bill, that it wasn't listed because the original bill was just talking about a study committee, but the amendment, which establishes that the position of the forensic liaison, there's going to need to be an appropriation for that, so that will probably have to go to finance now. So I would say that we probably shouldn't put that on consent.
Except that bills that are on consent can go to finance.
Oh, they can. I did not know that. Okay, all right, then let's put that on consent. Let's put 480 on consent.
And you just want to make sure that both Paul and Ken, Ken's still the chair, knows about that.
Right. Okay.
Clarification.
480 is now going on consent.
480 is going on consent. Sorry about that. I'm sorry for the confusion.
And the other two on the regular
The other
calendar?
two on the regular calendar, yes.
And there are no minority reports at all?
Are we understanding correctly, Representative Andrus, that you will not be writing a minority report, but you will let the clerk know that you desire to speak on whichever of these bills comes up first to express your view on the procedure.
Yeah.
No, that's fine.
Because to do a minority report, I gotta put it, retain it or something, and
Right, you need
it's
a
not
motion.
worth it.
Right.
480 is
Right.
on consent.
Okay.
Is 697 on consent?
Sure.
I'm thoroughly confused with this one.
And one on the regular, so I'm really confused.
Yeah, I thought HB 697 was also on consent.
Right. All right, so hang on. So here's what I have. 369 cannot be on consent because it's going to finance, and it's listed as an early bill. 480, even though it's not an early bill now, even though it will end up going to finance, I'm advised by Representative Smith, and I have no reason to doubt this, that we can put it on consent, so we will. And then the last bill, 697, where am I here? Hang on. 697, that can also go on consent. And two for consent.
And two for consent.
And no reports by the, right. Okay. All right. Good. Well, I'm pleased with, having been able to exec 3 bills. That's good. All right. So let's go get something to eat, and we'll be back at 1:00. So I'm going to recess the House Judiciary Committee. And thank you all.
in right-wing media like the Wall Street Journal, or, Slate and Salon, left-wing media, stories of people who got their bachelor's, their master's, maybe an additional degree. And we're following all along exactly what they were told by their middle school guidance counselors, their high school guidance counselors, their parents, the media. The president's getting up and saying, this nation, needs to get education. Education is the way to the middle class and the upper middle class. And the lenders are there and very eager to make all of these outlays to the students. So you want a master's degree in foreign affairs, undergrad in political science. Here is the check. Just sign here. What a lot of 17 and 18-year-olds, and that speaks, by the way, to the asymmetric negotiating position, what a lot of very naive 17 and 18-year-olds don't understand is that student loans are non-dischargeable. And that is something the federal government has chosen to do to make sure that lenders are there. If student loans were dischargeable in bankruptcy, you would see 29-year-olds with $300,000 in debt and effectively no tenable career path ahead of them, because they're in a career field that maybe is pleasing to them but pays $30,000 a year. They will never, ever, ever be able to pay off these loans. And then the federal government, in their wisdom, has also said that you cannot escape these loans even by declaring bankruptcy. You can declare bankruptcy. You can wash away your $20,000 in credit card, your $5,000 car loan, but you still have this $300,000, $400,000 of student loan hanging over your head. And a lot of the laments that you see from people are, I will never be able to afford to get married. I will never be able to buy a house. I'll never do this. I'll never do that. And obviously, I'm a registered Republican. There is a lot of rhetoric on my side of the aisle, not in the general court, but, in the populace as a whole, haha, well, that'll teach you to get a degree in underwater basket weaving, as the joke goes. And, it's in fact not really funny. These are people who made these decisions when they were very young. They followed all of the best advice that was given to them, and they are in an entirely untenable life path. Now, a lot of degrees are in fact useful, nursing degrees, STEM degrees, even, other degrees are tenable for certain people. If you are, a child of the wealthy, you can go off and you can get a history degree. You can follow it up with a history PhD. You can have a great career because you've got your, family wealth waiting there for you. But for a lot of other people who don't understand that, they've sort of walked into a Porsche dealership and they're being offered these luxury goods that are being sold under the premise that these are investments, it is a very bad situation. So that brings us to the actual bill before us right now. This bill defines certain educational services as sort of inherently fraudulent or deceptive. And so, let's get into that. Is this a subjective decision? Should there be someone who said, well, I got an engineering degree, so it's, if you majored in social work, that's inherently deceptive. No, that is the wrong approach to take to this. And there are a lot of degrees that at a certain price point are quite reasonable. Someone can, if you can get a history degree for, $25,000, $30,000, that's reasonable. The problem is if people are being given these degrees that will never pay for themselves. So there is some math in here, but I'd like to walk through the math. What do I mean by will never pay for itself? If someone graduates with a degree and gets an average job in their industry, and then they take 30% of their take-home pay, which is quite a lot. I remember being a 21-year-old and paying, half my salary just for an apartment. 30% of your salary every month for 10 years, if that can't pay off your degree, then you are effectively in a debt trap. If 30% for 10 years can't get you out, what possibly could get you out? Now, we talked before about if you were in a certain situation, maybe you were the, a Rockefeller scion, and you absolutely know that your passion is to, study Byzantine history, and you don't need to have some high-paying career at the end that is ever going to pay for this. This bill has a way that any student can just sign a waiver saying, I understand that this educational degree that you're selling me is not conventionally going to result in a conventionally remunerative career. There is also the issue that a lot of colleges offer degrees that are seen as very prestigious, especially in Asia. So a lot of colleges make a lot of money by selling degree programs to foreign students. This bill does not extend protections to those foreign students. Someone coming from mainland China and paying for an American degree is probably, got the means to do so. And it is not New Hampshire's business to meddle in their decision, nor in the university's business model of selling very expensive degrees to Chinese or other people. So that is an overview of the bill. And then finally, this provides two kinds of action. One is the Attorney General, if that office ever desires to do anything, could prosecute a university for offering a fraudulent service, but there is nothing in this bill that requires them to do so. If you look at the rest of the Consumer Protection Act, there are other things where the Attorney General has the authority. They can go after a store for offering going out of business sales every 60 days. They can go after a car dealer for offering certain services, but there's nothing that forces the AG's office to do that. So there's nothing here that compels the AG's office to do anything. Finally, one question that came up in the drafting with OLS discussions was, how would a student prove this? Is there a set criteria? There are, in fact, lots of surveys showing what people in various career fields earn. Universities themselves often gather this information internally and maintain it, but it is not the job of the bill to make anyone else's case for them. There are many cases in the law that give citizens a right of private action, and if a citizen, has the right to sue a neighbor for runoff, it is the citizen's job to go out and get a structural engineer or a groundwater engineer and prove their case and go to court. And this bill has that same standard. It does not do the citizen's job for them. I'm open to any questions, please.
Questions for this witness? Yes, Representative Paterno.
Thank you, Mr. Chair, and thank you, Representative Corcoran, for being here. I was smiling only because your analogies were amusing, not that over this situation. So I have a question about the Attorney General prosecuting. So, for example, if we have the University System of New Hampshire, which is a public college, we would have a situation where the state could possibly be prosecuting the state in this situation, and then after. So, what would you suggest in that situation, or would you address this specifically to private colleges?
I think that's a great question. And in the same way that the AG, if they choose to, weighing all of the merits of the case, weighing, the pros and cons of sort of, political situation and other thing, for example, chooses to go after a DCYF employee or a state police employee, the Attorney General, in their wisdom, can decide when something is egregious enough. Now, let me raise another point, also in response to this, that this need not be seen as sort of purely punitive and after the fact. If a bill like this existed, and if either a private college or a state college was tempted to offer a new 8-year degree in throwing ceramics at the wheel, they would have to ask, hey, is this likely going to put us in danger with this law? And that incentive structure is part of it. So it's not just after the fact what the AG might do.
Yes, follow up.
I'm sorry, it's not technically a follow-up, but have you ever seen or heard of situations in which the parents complete the FAFSA and take on student debt? That's not, the student doesn't necessarily know that this is happening because they're 17 years old maybe when they're applying for college. Parents fill out the application and agree to take on the debt. And sorry if it's in here somewhere. And then the student finds out upon graduation that now they're saddled with this. What's their recourse against their own parents?
Right. So I am aware of that. I think that is a tragic situation. And in this case, I believe that the wording here, where the parents sort of, effectively make the decision but offload the debt, it would be the student. Again, the metric is their salary, and so they would have recourse. And again, I would be thrilled if this bill were to pass and become law, if there was never a single lawsuit under this bill, but if instead universities said, hey, wait a second, we have been offering this one degree in a certain thing that no one ever gets employment in, or the employment is $30,000. Perhaps we should, merge that with another degree or change the requirements for it so that it becomes more lucrative. So yes, I think that's a great concern, and that also speaks to what I was introducing it as, where you've got 17 and 18-year-olds who are very naive, have a very rose-tinted glass view of the world, and can get themselves in a world of trouble. And it's one thing for an adult to make a decision. I'm going to rent that Porsche, I deserve it, and then after 6 years of payments, I really screwed up. It's another thing when a 17-year-old signs on the dotted line and at 45 years old says, "I wish I could afford a house someday."
Other questions? Representative Smith.
Thank you. So am I correct that you see this bill as an effort at consumer protection?
100% correct.
Thank you. Could I follow up?
Yes, of course.
Would you change your position at all? You began by making clear what political party you belong to, which I hadn't seen was relevant. But perhaps it is relevant since on the national level, it appears that the national government, the federal government, is challenging the existence of the entire consumer protection effort. Would that change your position on this bill?
So let me first say that the reason I introduced my own party was to say that I think that to some degree I'm arguing against interest, as a lawyer would say, which is you would expect in general it would be people on the left who tend to speak in favor of student loan forgiveness. And I just wanted to say that, I'm a person, who doesn't necessarily share all of those cultural, political norms, but still understand the sort of financial tragedy that many people are in. And speaking to changes at a federal level, obviously none of us in this room have any power at that level. But the great thing about the federal system is that there is the sort of, the 50 laboratories of democracy, and we can make our own rules here. And, were this bill to pass and were it to have both sort of retroactive applicability where someone having already gotten a deceptively advertised degree gets justice, and in the future, where because we set incentives, future people are spared that danger, I would think that this could be something that could perhaps be replicated in other states. So if you were worried that, the country is heading in a certain direction and might not be heading back for decades to come, that these states can do a lot to achieve justice for young people.
And if could I just ask one? Could you show me where in the bill, and maybe I just haven't read it carefully enough, it says that it would be retroactive?
As soon as that word came out of my mouth, I was immediately upset with my word choice. I did not intend to have that in there.
Thank you.
Other questions for this witness? So I guess I do have a question. Even without this, isn't the if there really has been an institution that has misrepresented the value of its educational programs, isn't that covered already under the Consumer Protection Act?
Thank you for the question. I believe it's not. And part of that is because what exactly do you mean by misrepresentation? And this again gets to power dynamics. If a university said, sign up for our anthropology degree, we guarantee you that this degree will pay for itself and it will be guaranteed entrance to the middle class, where the middle class is defined as this income to that income, then a student would, have a very strong case. But, having gone through college myself, at all times, there's this, welcome to a brand new world. This is your pathway to the future. Pathway to the future is the kind of language that's used all the time. And you can't, go to court and say, but Your Honor, the Dean of Students said it was the pathway to the future. Well, it's now the year 2029. Congrats, you're in the future. There has never been, to my understanding, any sort of case against universities under existing law, and yet universities under existing law continuously offer degrees that end up costing hundreds of thousands of dollars and can never pay for themselves.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you very much for your time.
Next, I'm going to call on Lauren Banker, please.
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Lauren Banker. I serve as the Director of Government Relations for the University System of New Hampshire. We are here today in opposition to House Bill 722. I just wanted to provide a few points, and then I'll say this is not an area that I have a lot of expertise in, so if I can do some follow-up with my colleagues back at our campuses, I'm happy to do so. I'll start by saying that affordability and accessibility are core values of our institutions, and that we take great pride in providing opportunity to each of our students and equipping them with the experiences, knowledge, and skills to thrive in their career. But while we appreciate the sponsor's goal, we have several major concerns with the proposed legislation. I'll hit on two things, and then the backside of my testimony has a little bit more as well. The first being that the bill would require detailed earnings data for graduated students by degree program to determine the average annualized 4-year pre-tax inflation adjusted salary of grads of each of the degree programs. We do not and could not capture this sort of detailed earnings data for each of our graduates, and that this requisite level and completeness of earnings data is information that would only be available through the IRS. We are currently working diligently to comply with recently enacted federal regulations with regards to financial value transparency and gainful employment. All of our institutions have recently, I think as of January 15th, submitted record level student data that will be matched with national student loan and IRS earnings data. And this data is going to be analyzed and posted to a publicly facing website in order to provide students and families with a clear, comparable information about financial outcomes of educational programs. So above all, this work is being done on the federal level, that we are following all the regulations and reporting requirements. We've been investing hundreds of hours to collect, review, analyze, securely transmit, ensure the accuracy of this data as required by the federal legislation. So ultimately, this bill is seeking to create a duplicative process and create additional and unnecessary administrative and financial burden on our institutions at a time where we're already facing significant financial constraints. I'm happy to answer any questions for the committee. Thank you.
Questions? Yes, Representative Horrigan and then Representative.
Thank you very much. Is it fair to say that one extenuating circumstance, especially for major universities like UNH, is that they rely heavily on alumni donations? So you do have an interest in making sure your alumni earn enough money, not just to pay off their loans, but even have something left over for other things in life, including donating to their alma mater.
Yeah, as an alum of UNH, I definitely have that affinity. Yeah, thank you.
Representative Smith.
Thank you very much. I'm interested in this bill, and I'm not sure kind of who's on first in terms of whether it's the university or whether it's a lender, not a grantor, but a lender or whatever. So it's a little confusing to me. But can you tell me when a student applies for whatever particular academic pursuit, are they given either a guarantee or a statement by the educational institution that if they enter such a degree program, they will be guaranteed a certain income as a result?
I don't know specifically what each of the campuses are doing with that regard, but I'm happy to follow up with our career offices and see. I know there's been a lot of investment in energy and resources into our career and professional success offices at each of our campuses. So I know that this is something that they value, and I'm happy to follow up.
Could I repeat that question?
Sure.
Do you really mean to tell me that it's a possibility or a probability that any employee of a university will guarantee to an applicant what their income will be if they pursue a particular degree?
I don't know. I don't think so, but I don't know.
Thank you very much.
other questions for this witness? Seeing none, thank you very much.
Thank you.
Up next, I'm going to call on Brandon Garad. Is that right? Please.
Thank you, Mr. Chairperson, members of the committee. My name is Brandon Garad. I am a Senior Assistant Attorney General. I am also the Chief of the Consumer Protection and Antitrust Bureau at the New Hampshire Department of Justice. I am here before you neither in support nor opposed to this bill. I think that the merits behind this bill and the cost of an education are a concern that is shared pretty much across the board by everybody. But as the Chief of the Consumer Protection and Antitrust Bureau that will be responsible for enforcing the provisions of the statute, I think that it's important that when considering this legislation that this committee think about two important issues. One is enforceability, and the other is practically the resources that it would take to implement what this bill anticipates. I'll start by noting that I do see that a request for a fiscal note was made, and I apologize that we did not provide one. As the consumer chief, all of the consumer protection related fiscal notes are usually sent to me. I did not see this one. This must have fallen through the cracks. So apologies for that, but I think I can provide the information that would have been contained in a fiscal note to the committee today. I don't often appear before this committee. Usually the consumer protection bills are in House Commerce, so I thought it might be helpful to just give a general sense of, if this were enacted, how our Consumer Protection Bureau gets information, gets complaints, and decides on investigative and enforcement priorities. We have a consumer protection hotline that is open 5 days a week. It is manned by volunteers. Anybody can call in and speak to a real person who believes they have an issue that may be a violation of the Consumer Protection Act, or maybe something that any member of the Department of Justice might be able to help with. The majority of those folks who identify plausible consumer protection violations are steered towards filing a consumer complaint in writing with the Bureau. I review every one of those complaints, and for those complaints that have any semblance of merit, based on a possible violation of our statute, we send them to the business and we ask the business to respond in writing. Many businesses do, and many businesses resolve those complaints by responding in that way. For the ones that don't, or the ones that don't in a satisfactory way, we have the discretion to open a larger investigation, issue subpoenas, talk to witnesses, and if we build a case that an unfair, deceptive act or practice exists and has been committed, we have the ability to pursue both criminal charges if appropriate, or to bring a civil enforcement action to enjoin the conduct and seek fines and restitution against the offending business. So, I think that's important context to understand, because the sponsor is not wrong to say that this does not require the Attorney General Office to do anything under this bill, but anytime you're adding to the Consumer Protection Act, which is enforced, certain parts of it are enforced exclusively by the Consumer Protection Bureau of the Attorney General's office, it creates a perfectly fair expectation amongst consumers in the states that if they are the victim and have been wronged by unfair, deceptive act or practice, that they can turn to the Attorney General's office, who will take their complaint seriously, investigate it, and if appropriate, bring an enforcement action. So, that discretion of whether or not to proceed exists across the board. But anytime a bill is passed that entrusts us to enforce any new provision of consumer rights in the state, we want to make sure that it's passed in a way where we can actually do it if there are complaints, and if there are violations, that we can provide meaningful enforcement of that statute. Otherwise, it's mostly just for show. And I think there are real problems here. And the first part of it comes with, I think that, some of the comments that were submitted by the University System of New Hampshire, there's significant resources that would be needed at a minimum just to allow the universities themselves to be able to compile the data that we could then, either subpoena or request and review in order to determine whether or not the amount being charged is in excess or in line with the threshold that's created by the statute. So unless those resources are allocated and the universities are able to meaningfully put this data together, we would be left to either do that work ourselves, which we are not in a position to do, or to be left unable to enforce the statute because we wouldn't be able to determine whether or not the average tuition as anticipated by the statute is or is not in excess of the threshold that was created. If those resources were allocated such that the universities could provide those numbers, it would still require significant additional resources at the Attorney General's office to meaningfully enforce the statute. The Consumer Protection and Antitrust Bureau is enforced with enforcing all of the consumer protection and antitrust statutes in the state, which was recently expanded to include data privacy. We're also tasked with registering all the health clubs in the state, all the condominiums, land sales, enforcing the state's tobacco related statutes, and investigating and prosecuting the most serious cases of elder financial abuse and exploitation, just to name a few. And we regularly hit above our weight in terms of the resources that we have and all of the things that we are expected to do. I think we do the best with what we can, and we get meaningful results for consumers, but this would be a significant expansion that would create a 10-year right for every single graduate in the state to file a complaint with the AG's office. And just reviewing those complaints and meaningfully investigating, issuing subpoenas, reviewing the documents that would come in response to those subpoenas, doing a meaningful calculus to determine whether or not the tuition being charged is or is not in excess of the threshold anticipated by this statute would require additional resources, probably in the realm of 3 additional employees, in order to meaningfully do this in the way that is anticipated by this statute. I think the chairperson asked a good question earlier, which was, is this already covered? And I think that it is, to the extent that any university is making any sort of claims about what income you will receive or can expect to receive, unless it is firmly supported by statistics that they can support and guarantee for those folks that are enrolling in their program. There's obviously a number of variables, including, how successful the student is in their coursework, what, jobs they ultimately pursue, what internships they pursue, that determine, the amount of income that people can get. So I think because of that, universities more likely than not are very unlikely to make those sorts of representations, but it has happened in the past. There were several for-profit colleges, including ITT Tech, that were making those types of representations to students, essentially guaranteeing a certain level of income if they were to complete their programs. And those colleges were jointly investigated by the New Hampshire Attorney General's office, as well as the majority of the Attorney General's offices across the country, and were required to pay significant fines and stop their practices. So to the extent specific representations about the amount that you can expect to earn are being made and are not true, that would be an unfair and deceptive act or practice under our existing statute, even though it's not a specifically delineated unfair and deceptive act or practice. So I think that's all the testimony that I have today. I'm happy to take questions if there are any.
Question, Representative Horgan.
And do you feel, what do you feel about the fact that the universities don't really have they don't really have the capacity to control what life choices their graduates make after they get out of school, and also so people often make life choices. They may get a degree for a high-paying job and then decide some other type of work interests them. That applies, for example, to all of us around the table who are making $100 a year as a state rep. But and also, what about things that are not voluntary? People, like sometimes some people unfortunately then acquire chronic illnesses and they can't do the high-paying job they were trained for, and there's all kinds of other circumstances. So, what sort of difficulties do you think the bill poses in that regard, that they're asking universities to be liable for things that aren't under their control?
So without getting at the merits of the bill, I do think that the issues you've raised highlight some of the difficulties that we would have in enforcement. All of that would need to be considered, and all of that would need to be calculated in order to meaningfully determine whether or not a college or a university was in violation of this statute. So I think that, those are certainly concerns, and they go right to, I believe, our ability to meaningfully enforce this and gather all the data that would be necessary to truly determine whether or not tuition is excessive or not, or unreasonable or not under this statute.
Other questions for this witness? Seeing, I'm sorry, Representative Bergeron.
Thank you, Mr. Chair, and I do appreciate in advance. I was curious because I know 5 years ago when Betsy DeVos was actually in DC, I was for the Department of Education. I was really curious because I know that there were a lot of colleges, Capella, people like that, that were actually making a few offers that they probably shouldn't, but I just know that that was sort of supported from the Department of Education at the time. So I guess, do you see any of kind of like that involving with this at all?
I mean, could you
'Cause
be more
that was
specific
that-
as to what you're referring to?
It's like GI Bills, things like that, where colleges took advantage of, you know, the education funds that vets have.
I'm not sure how much overlap there would be there. This is strictly about the cost of tuition for a specific degree program. So I suppose that could impact it one way or another. I mean, there are a number of factors that could influence both the price that a university charges, but then ultimately what the average salary based on all the graduates combined using all the factors under the statute, what that number actually is. And comparing the two numbers, I think that's the difficulty that I think we would face in enforcing this in a meaningful way.
Yeah, because that wasn't fun. Thank you.
Other questions? Seeing none, thank you very much, sir.
Thank you all.
Is there anyone else who wishes to testify on House Bill 722 FN? Seeing none, I'm going to close the hearing on 722 FN. And we're a little bit early, so I'll hang on before we open the hearing on the next bill. Oh, that's. Yeah. Okay.
This is
690. Wait a minute, hang on. Oh, yeah. 697. 697. Okay. It's now 1:45. And I'm going to open the hearing on House Bill 746. Is there anybody here that that wants to appear on that bill? I don't see anybody. Could I, Representative Bergeron, could I call on you just to introduce the bill? You don't. All you have to say is just go to the thing and say you're introducing it, and that'll be all. Thank you.
It's getting good.
Yeah,
Thank you very much.
you're on default. Introduce.
Thank you, Mr. Chair. I would like to start out and talk about 746. Yep, 746 FM, relative to an award of attorney's fee upon a successful appeal of a local property assessment.
Thank you very much.
Any questions?
All right. So, is there anyone who wishes to appear in support of HB 746? Anyone else who wishes to testify? Seeing none, I'm going to close the hearing on House Bill 746. All right. I wish we actually had somebody. I mean, I think as a general matter, it may not be a bad idea, but I do have a couple of questions about details. At any rate, maybe when we schedule an exec session, somebody will appear for that. So, so we have some time on our hands before we get to the last bill. Oh, I'm sorry. I will close I think I did, but if I didn't, I'll close the hearing on 746 FN. Yeah, I know. I'm not sure there really is anything else we can. We don't have enough. Yeah, we don't even have enough people. Yeah, 1, 2, 3. 8. Yeah, you're right. Only 8 people. Only 8 people. All right.
I just know
Yeah.
what to do.
Yeah.
Does anyone want us to use a 3?
Oh, oh, you know, Representative Kutaba, I'm going to go talk to Karen right now to switch them. Oh, thank you. now 2:30, and I'm going to open the hearing on House Bill 762 FNA, and I will recognize Representative Linda Hoskins, the appearing for the prime sponsor.
Good afternoon. Thank you, Mr. Chair and members of the committee. For the record, I am Representative Linda Haskins from Exeter, Rockingham 11. I'm here to introduce 762 on behalf of Representative Zoe Manos, who's ill today. I am also a co-sponsor of this bill. The purpose of the bill is to enable the judicial branch to hire an independent contractor to conduct a manual review of domestic violence, stalking cases, and related criminal cases, to compile and collate data for statistical analysis by the judicial branch. It authorizes an appropriation of $30,000 to do this. Without proper data, it is impossible to determine where and what resources are needed in domestic violence and stalking cases and related criminal cases within the judicial branch. Right now, the judicial branch only keeps records in domestic violence and stalking cases on paper, in paper files. There is no electronic filing in these cases, and no coordination with related criminal cases is very limited. The circuit courts cannot see data across the cases or the country or statewide. In order to determine and evaluate what resources are necessary, the first step is to gather data. And that means manually reviewing the paper case files to gather the data. This bill will enable the judicial branch to hire an independent contractor to do this. It's important to emphasize that no personal information that identifies any party will be gathered or recorded. The data is used for statistical analysis only. The bill recognizes that the judicial branch may be able to secure funding from other sources. If so, those funds would be applied prior to this appropriation. It is critically important that we collect this data. It will enable us to determine what additional resources are needed by the judicial branch in domestic violence and stalking cases and related criminal cases. It will also enable us to determine what additional resources are needed to support victims and what resources are needed to allow perpetrators to address their violence. Attorney Erin Cregan, who is General Counsel to the Administrative Office of the Courts, I believe is represented here today to testify as well. Pamela Keelig, who is the Public Policy Specialist for the New Hampshire Coalition Against Domestic and Sexual Violence, was not able to stay, but you have her information, her testimony, and she would welcome contact from the committee, any questions or information that you might want. I am not prepared to answer questions. There are others who are more knowledgeable than I, so I would refer to those folks for questions. And I have a caucus, so I'm not able to stay. But it is a pleasure to see you all and to introduce Zoe's bill. It's a very important one. Thank you.
Thank you. All right. Next, I'm going to recognize Anthony Kinney, please.
Push the button.
Thank you.
Good afternoon, representatives. My name is Anthony Kinney. I'm from Middleton, New Hampshire. I'm here to oppose this bill. In just a few short words. Just give me 1 second here. I don't know why this is not working. My notes. Anyways, I have a family case, 630-2020 DM 42. That's my family case. It relates to a criminal case where my ex had assaulted me and was criminally arrested in 2017. That's 464-2017 CR 430, where she was arrested for simple assault. Criminal charges were brought up, and we had those dismissed. And then we started our family case in 2020. And in 2022, she got a bogus DV stating that the 2017 incident was me hitting her, even though it's documented. That's case number 630-2022 DV 21. And after witnessing my son get assaulted and attacked on numerous occasions, called for welfare checks. And I reached out to the first line of communication between a parent and their child is the other parent. I was then held criminally on several charges.
So, you know, sir, I guess I'm really trying to what is all the details of some particular case have to do with this?
Well, I disagree with this bill, especially if it's not going to pronounce names, to spend $30,000 when Gordon McDonald had just said that, you know, there's not enough money for a trial. Okay, so these 3 criminal cases, 2 of them were simply calling the police department for a welfare check. They held me for third-party communication, 60 days without bail. And when I asked for a de novo hearing in front of a jury, they told me that I would have to remain in preventative detention until that trial. These were bogus cases, all related to family court, all related to DV, domestic violence, where she was the one who assaulted me. And then later on, even though I had evidence at the hearing, the judge didn't want to see it, and I was then held. They gave a final DV order in the family case where there was already problems communicating. And when I reached out to protect my own son, I was then arrested and held without bail. And when I was tried, maliciously tried, and asked for a de novo hearing at Superior Court, they gave me a new bail hearing, the Circuit Court, and said that if I wanted to have a jury trial, then I would have to remain. This was the day of my release. I had already served my sentence. I would have to remain incarcerated unless I would draw. So I don't understand why you would want to spend $30,000 on anybody investigating, especially if you guys have the power to subpoena and possibly impeach any of those bad actors that have kept my son in harm's way for 5 years. When I was retaliated against through the family court, it was the same judge in her criminal case in 2017, the same judge in the DV case, and the same judge in all 3 criminal cases that were all brought on allegations alone. I don't understand why you want anybody to investigate. You can investigate my case. I'll give you this paper. You can investigate the case with Joe Nugent, Stephanie Turgeon, Lindsay Smith, Destiny Bernard, Harmony Montgomery, Ruggiero and Ruggiero. You must know that case. Matthew McDonald. All family cases, all domestic violence been related, all criminal, and all hogwash. So there's plenty right here on this one page for this body. If you want it, you don't have to investigate. You don't have to go far.
We can just decide to impeach those judges.
No, what I'm saying is there's plenty to investigate right here without spending $30,000. All you have to do is pull up these case numbers. Okay, there's plenty. It's all related to this bill without spending $30,000, which we could put back into, let's have 2 more weeks of jury trial. Let's keep that jury going. There's no reason that this body or the representatives or the Democrats or wherever the money's coming from should have to spend that money. If there's already enough, and I could go on, I could give you all these docket numbers before you leave here today, and I could give you a list of 30 more people. There's no reason to dig in with $30,000 starting at scratch.
Okay. All right.
Any questions?
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'm going to call on Dana Albrecht, please.
Good afternoon, Mr. Chair and members of the committee. For the record, my name's Dana Albrecht, Nashua, New Hampshire, and you should have 3 handouts. One is in just a summary of an email I sent everyone this morning that has a large number of attachments. No need to kill trees, but you've got a complete record there electronically of the current proceedings that the judicial branch has done under Justice Marconi to address domestic violence. So there was a lot of prior work on this by Justice Marconi. You've got, in terms of budgeting, the presentation by the Chief Justice to the Joint Committee of Judiciary and Children and Family Law. So that's all pretty relevant to budgeting on this. And you've also got one federal court case that I think is relevant. Excuse me. I'll find it when I come back to it. It's Kelly v. New Hampshire in Federal District Court, New Hampshire. When I kind of tried to figure out what's going on in these cases, the judicial branch, I requested training materials. That's one of the handouts. And apparently this is a huge deal because General Counsel Cregan said that in June of 2023, domestic violence topics constituted the bulk of the training for circuit court judges, with 3 full days devoted to the topics for recently appointed judges and a full day for other judges. So we seem to be spending a whole lot of money on this with extremely little transparency on how it's actually being spent, how these judges are actually being trained. And that's particularly concerning, you know, when other jurisdictions, like over in the Fifth Circuit, the Federal Appellate Court, there is made very clear that these kinds of orders are essentially granted to whoever shows up to court first. We already know that. Thank you. We already know that. They're granted against people like David Letterman because somebody was afraid of him on TV. We know that. They're granted to whoever goes down to court first. The Fifth Circuit specifically referenced training materials in its opinion, and that these training materials are the problem. And if, you know, this body or we the people can't even see these training materials, why should we be throwing $30,000? None of these, Lindsay Smith, who's the domestic violence shooting victim who was brutally shot after Polly Hall denied a restraining order, hasn't gotten a single penny from the state. Maybe she deserves some resources and not the judicial branch. Maybe we should devote resources towards jury trials. Miss Smith's one of her closest friends, Miss Destiny Berard, was also incarcerated in preventative detention for 3 days. No right to a jury trial, no access to counsel. You know, once again, because of this phenomena of whoever goes down to court first in this so-called civil proceeding automatically gets the order. So the statute itself, 173B, it's an unholy amalgamation of civil and criminal law where the respondent is subject to all of the penalties of the criminal justice system and has none of the rights normally afforded criminal defendants in the criminal justice system. There's a de facto practice where the plaintiff in the so-called alleged civil 173B cases is essentially presumed to be correct unless the respondent, again in a so-called civil case, after the fact, manages to prove beyond a reasonable doubt they're innocent. This is a complete reversal of traditional American jurisprudence. You're putting domestic violence victims in jail now, in preventative detention, solely because their abusers were the ones who went to court first. And you want to spend $30,000 to study more of the same when, you know, Justice Marconi has already been all over it with 10 meetings. We've got 15 meetings at the Governor's Commission, and nothing's come with that. So I really question what we hope to get for this $30,000 when, as you know, Mr. Kinney, the prior speaker, said, so many people have shown up to testify and can give you all the problem docket. So I would propose we either ITL this or we replace it with some kind of investigatory study committee in the legislature to really address, you know, the constitutionality of 173B. You know, otherwise, like the federal court opinion passed out, you know, right now we have people starting to challenge, you know, those statutes in federal court. And I would only anticipate that's going to continue as we go further and further downhill, putting innocent people in jail in preventative detention with no right to a jury trial just because they're DV victims and their abusers made it to court first. With that said, I'll take questions.
All right. Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'll call on Aaron Cregan, please.
Good afternoon.
Afternoon.
Erin Cregan, General Counsel for the Judicial Branch. Just coming to discuss this bill, which I really appreciated that Representative Manos reached out to us and had a general question: what was the best way to get answers to specific factual questions? And I think she's still working with stakeholders on what she wants those questions to be that would be fact dependent in order to show how common or uncommon certain factual characteristics are in DV cases. I haven't seen that list from her. I know she's working on it, but we had a chance to engage with her about potentially the best way to do that, which is because over 95% of these cases are in paper, it typically involves a human going and looking through the paper for certain characteristics. So for example, I think she had said something at one point to me about how many children are under a certain age involved. We would have to review that manually from the record. So that. I think this is the correct way to do that if it is what the legislature would like to do. And I appreciate her collaboration and work to kind of do it in a way that was something that we could action. It is absolutely up to the legislature whether to appropriate this money for this purpose. But I do know that this is a source of enduring questions that we have. People want to learn more about the features of different DV cases. So I do think there is a demand, should it be your desire to fund it. But I'm not aware that there is any other way besides an actual manual review of the paper that we could get the level of detail that people have been seeking of cases.
Great. Questions for this witness? Yes, Representative Tripp.
Thank you for taking my question. I know you're not the sponsor of the bill, but you seem to have been involved in the writing of it. And I'm interested in what the use of the, or who's going to be using this data, because it talks about the Judicial Branch, Governor's Commission on Domestic Violence, Sexual Assault, Stalking, and other interested individuals or persons. You know, do you have an idea who the other interested persons might be?
I don't. But I suspect it would be those that are involved in the space. So thought leaders, people who work at nonprofits, people who are maybe affiliated in a loose way with the Coalition on Domestic Violence. I would expect that it would be folks that typically appear at meetings on this subject.
Follow up?
So I would assume that the data that's collected during this time would be published somewhere.
My expectation is that we would publish it in a report that would be available on the website, because this would be statistical data. How often are young children involved? How often are certain facts present? It would not reveal any individual person's private information. So it would be answering questions that people sometimes have about how common certain factual characteristics are in DV cases.
Yep, go ahead.
One more. Do you have any idea of how many years this review would cover?
I believe that that was intentionally left vague because of we don't have the questions. So if we receive a very large set of questions, $30,000 may only go back a few years. If we receive a small set of questions, we may be able to go relatively far back in years. So I think that that was not specifically set because we don't have the questions yet.
Thank you.
Other questions for this witness? Yes, Representative Petternow.
In this modern day and age where we have all of our data on electronic devices, why are these all only on paper?
It's a great question. Not so long ago, almost all case types were paper case types, and it is a cost of over $100,000 to transition a case type. So we have been slowly over time transitioning case types from paper to electronic over a decade. And many of them are now electronic, but there are a few that are not. The reason that this one hangs around on the list is a fewfold. One, if we did make it digital, it would probably need to be handled a little bit different. So it would need to have certain features that you would expect to see for DV cases, like an escape button the person can press, which will normalize their screen so that if their abuser is right behind them, they don't see that they were working on a petition. So the bidding is a little bit higher for that. So, and we just haven't had the extra funds to transition this case type. It is something that will happen eventually.
Other questions? So, Ms. Green, I guess I just have one question. The only thing that concerns me is the bill doesn't say, it says, the independent contractor conduct manual review of domestic violence and stalking cases and related criminal cases in order to compile and collate data for statistical analysis. I guess my only question is, this doesn't say what will be, what data will be captured or whatever. So, I mean, if we pass this bill and the $30,000 is appropriated, do we have to worry that there's going to be a fight among, some interest groups about like, well, capture this data, but not this data, or capture, this much, but not. So I'm wondering if you see that as an issue that we ought to address, perhaps by an amendment or whatever.
I would not want to speak for the prime sponsor, but it is my understanding that she was going to offer an amendment once those questions were set. She had a deadline that she had to hit with submitting the original bill and was working on those questions. I would hate to be incorrect in that, but I believe she did want to set those questions with the universe of people who have been seeking data of one kind or another and then seek it by an amendment. I think there also may be an amendment on the funds appropriation because those that deal with federal funds know that they typically have supplantation limitations, which is that you can't supplant state spending. So there is just a little tweak that needs to be done to one line here so that we don't accidentally get in a situation where we can't get federal funds or state funds because of how it's phrased. There are some things coming up in September that we could apply for, but it just has to be phrased in such a way that it's not supplanting.
Okay.
So I do believe there is an amendment coming forward that would make that correction and probably add the list of questions for your consideration.
Yeah. Okay. Great. Thank you. Just making some notes here before I forget. All right. Questions for this witness? All right. Seeing none, thank you very much.
Thank you.
All right. Is there anyone else who wishes to speak on HB 762 FN? Mr. Albrecht, you have something else you want to say? Sure.
Just one follow-up. I heard these aren't in electronic form, yet they're regularly faxed to and from the judicial branch. So I'm curious why don't count as electronic storage and whether any of those faxes are retained electronically. And I think that should be addressed. Thank you.
All right. Thank you very much. Any questions from Mr. Albrecht? Seeing none, thank you. Is there anyone else who wishes to testify on HB 762 FNA? Seeing none, I'm going to close the hearing on HB 762 FNA. And I think we are done.
Two.